Voraan had rendered 4,217 verdicts in 200 years on the Galactic High Tribunal bench. He remembered each one with the crystalline precision of his species' neural architecture, not as memories exactly, but as stored decision pathways. The calculus of each case permanently integrated into his processing matrix. He could retrieve any of them instantly, the evidence weighed, the law applied, the verdict calculated, the gavel struck. A library of conclusions, perfectly organized, every shelf labeled. He did not remember struggling with any of them. He would remember struggling with this one. The chamber was designed to project the weight of law. Voraan had always appreciated this about it. The soaring ceilings of dark polished stone. The elevated bench set above the floor in a configuration that put the arbiters literally above the proceedings. The deliberate acoustics that carried every word with equal clarity to every seat. The forum built its diplomatic chambers to feel like government. The tribunal built its chamber to feel like judgment. The difference, architectural and otherwise, mattered. He took his seat at the bench as the chamber filled, his crystalline neural structures, visible as faint geometrical patterns beneath the translucent skin of a silicon-based species that had been processing information for 400 years, pulsed, their standard pre-session blue, stable, ready. He noted the gallery, packed. Humanity on trial drew attendance from every delegation. He noted this without judgment. It was data. To his left, Arbiter cynic, Thessari, experienced, reliable. To his right, Arbiter Dor, Cathari, precise, formidably analytical. Both had reviewed the charges and indicated in pre-session consultation that they anticipated a straightforward proceeding. Voraan had indicated nothing because a chief arbiter who indicates anticipated verdicts before evidence is presented is not a chief arbiter performing the function properly. The chamber settled. Advocate General Theskvan rose at the prosecution table. He was, Voraan acknowledged, with the dispassionate recognition of someone who respected competence, impressive, Gathari exoskeleton in deep amber, quick language cadence, calibrated for the translation matrix with the precision of 80 years' practice. He had never lost a case. The gallery knew it, the defense table knew it. Voraan knew it and filed the knowledge in its appropriate compartment, which was irrelevant to the evidence. The charges were these: humanity, over 30 years of forum membership, had violated the sovereignty accords 340 times. Unauthorized military deployments, unsanctioned border crossings, unilateral humanitarian interventions in sovereign territories without invitation or approval. Theskvan presented them in chronological order, each violation documented with date, location, involved human units, and the specific accord articles violated. His case took 3 hours. It was, from a purely structural standpoint, flawless. No gaps, no ambiguities, no overreach. He cited precedent for every category, applied it correctly, and concluded with the legal determination that humanity's pattern of unauthorized intervention constituted not an isolated series of infractions, but a systemic disposition, a philosophy of action that treated the sovereignty accords as advisory rather than binding. The law, Theskvan said, was clear. The violations, Theskvan said, were documented. The danger, Theskvan said, was real. Voraan's crystals pulsed steady blue throughout. The case was indeed clear. The violations were indeed documented. He processed Theskvan's argument and found no structural flaw. His preliminary computational state, which was not a verdict but was the thing that precedes a verdict in the way that a developing photograph precedes an image, settled toward a particular outcome. Then the defense attorney stood up. Dr. Margaret Holden was small. This was the first thing Voraan processed, because he processed physical data with the same neutrality as informational data, and her physical dimensions were objectively small, a compact silver-haired human woman in her early 60s, moving to the center of the floor with a cane that she used with the practiced ease of long habit. She moved slowly enough that the chamber went quiet, watching her arrive. Voraan noted this, the quiet, the deliberate pace. He filed these under strategic without judgment. She said the defense concedes all 340 charges. The chamber produced the sonic signature of a space that has been surprised, a collective shift in acoustic quality that his auditory sensors registered as approximately 90 simultaneous intakes of breath. Theskvan's exoskeleton produced a click pattern his translator rendered as surprise. A prosecutorial reflex, Voraan judged, that the Advocate General immediately wished he hadn't broadcast. A concession of all charges was, in procedural terms, a conclusion. The trial was over. The verdict was determined. Holden continued before Theskvan could object. Humanity violated the sovereignty accords 340 times. This is not in dispute. What is in dispute is whether the accords, as applied in these 340 instances, serve the purpose for which they were created. The defense requests permission to call witnesses. Theskvan objected. Witness testimony was irrelevant when guilt had been conceded. The trial was over. Holden countered. Sentencing required context, and context required testimony. She cited precedent. Correctly, Voraan verified in real time, matching her citation against his stored case archive. The procedure supported her position. Sentencing hearings permitted contextual testimony. Guilt had been established. The testimony would pertain to context for sentencing determination. Voraan ruled in her favor. The law supported her. He noted the sound Theskvan's exoskeleton produced at this ruling and classified it without engagement. The first witness was the Krellian ambassador. She was middle-aged by her species' reckoning, with the particular stillness of someone who has processed something that cannot be unprocessed. She described the Krellian colony crisis with the measured precision of someone who has told the story many times and has learned that precision is what makes it bearable. A systematic slaughter of Krellian civilians by an occupying force. The Krellian government had petitioned the Forum Council for intervention. The council convened. The council debated. Day 1, debate. Day 2, debate. Day 3, procedural question regarding intervention threshold criteria. Day 4, through the 47th parallel on the colony's eastern continent, a human carrier group diverted from a training exercise without authorization, crossing 2 territorial boundaries in the process, and positioned itself between the occupying force and the remaining civilian population. The occupying force withdrew. The killing stopped. Holden's examination was economical. Was the ambassador consulted before the human intervention? No. Had she formally requested it? The petition was to the council, not formally to humanity. Was she glad it happened? The translator rendered the ambassador's response with a faint lag as though searching for the most accurate equivalent. My daughter was in the civilian zone. She is alive because a human captain broke your law. Voraan's crystals flickered, not rapidly, just once. A shift in processing state that neither of his fellow arbiters would have noticed, but that was, internally, more significant than it appeared. The statement was not legal argument. It was data of a different category. He filed it in a compartment he didn't have a standard label for. Theskvan's cross-examination was correct and careful and completely unable to change what the ambassador had said. The second witness was a Velny scientist, angular, quiet-voiced, with the particular precision of a researcher who communicates in data because data is reliable in ways that everything else isn't. He described the Velny wasting plague, 10,000 Velny per month. The Council's medical committee received the petition for research assistance and tabled it for priority assessment, a process requiring 6 to 8 months. During that assessment, human xenobiologists, working in their own facilities, on their own funding, without waiting for council authorization, developed a treatment and deployed medical teams to the Velny homeworld. They had saved an estimated 200,000 lives. Theskvan's cross-examination raised the absence of formal invitation. The human teams had deployed to sovereign Velny territory without that world's formal request. Procedurally correct. The scientist's response to this procedural point was delivered in the flat tone of someone who has thought about a thing until it's simplified completely. We were dying. We didn't care about formal invitations. We cared about not being dead. Voraan's crystals produced the discordant tone. It was involuntary. The tone was the auditory signature of his processing encountering a genuine paradox. 2 valid conclusions that could not both be true simultaneously. He had not produced it in over a century and was aware that his fellow arbiters had turned to look at him. He suppressed it, filed the paradox, processed the next witness. The Surrey captain was steady-voiced and direct. 8,000 displaced civilians. a refugee convoy traveling through an active war zone. Forum escort requested to be approved but unavailable for 9 days due to deployment logistics. Human warships, already in the adjacent sector, crossed 3 territorial boundaries to escort the convoy through. Fired upon twice, returned fire. Delivered all 8,000 to safety. Thespon's cross-examination was technically correct. The human ships entered sovereign territory without permission. The captain's answer was not a legal argument. It was a refusal to let a legal argument be the point. They entered a kill zone full of refugees who would have died without them. Thesquin said, "That is not what I asked." The captain said, "It is the only answer that matters." Voraan's discordant tone sounded again briefly. He did not suppress it. The fourth witness was not a species humanity had helped. It was a Growlak soldier who had fought against them. He was massive by the standards of most species in the chamber. Growlak physiology built for a gravity that most inhabited worlds didn't replicate. He moved to the witness position with the particular deliberateness of someone who is thinking carefully about every word before they say it, which was not, Voraan judged, the Growlak's natural mode. He had been a soldier. He had fought humans in a border skirmish. His unit had been overrun. He had been wounded badly enough that he expected to die or be captured. Instead, he said, human medics crossed the field under fire. They treated his wounds alongside their own casualties. They evacuated him to a human medical facility where he spent 3 weeks recovering before being repatriated. No interrogation, no conditions, no demand for intelligence. He asked the medic why. She said 3 words, "Because you were hurt." The chamber had been quiet before this moment. After it, the quality of the silence changed. Voraan's crystals produced the bright, sustained pulse of significant variable reweighting. His discordant tone did not sound. Something else happened instead, a pattern in his crystalline structures that he had not produced before, which he could not categorize using existing labels, which he would, later, spend considerable processing time attempting to describe and ultimately leave classified as pending. Holden rested her case without further witnesses. The testimony stood on the floor of the chamber like the 47 Theta 12 names stood in a casualty report, factual, specific, immune to reframing. Thespan delivered his closing argument, and it was, Voraan assessed without personal feeling, correct. The sovereignty accords, the Advocate General said, exist because unauthorized intervention, however well-intentioned, establishes a precedent that any species can violate any border for any reason they declare righteous. Today it's humans saving refugees. Tomorrow it's a species with different values, saving a population by conquering them. Citing the same humanitarian precedent, the law does not distinguish between good interventions and bad ones, because the moment it allows that distinction, every species defines good as whatever serves their interest. The framework that prevents galactic chaos is only as strong as its universal application. Exempt one species for good intentions, and you've built the door through which every subsequent violator will walk. He was right. The legal reasoning was sound. Voraan ran it through his processing 3 times and found no flaw. Thesquan knew it. Holden knew it. Voraan knew it. Their GA knew it. There Holden stood. She walked to the center of the chamber floor at the same pace as before. Deliberate, unhurried, the cane a rhythm that the chamber had learned to wait for. She turned to face the bench and said, "Advocate Thespan is correct. The law is clear. Humanity broke it 340 times. His argument about precedent is correct. If you acquit us, you create a framework where any species can justify unauthorized intervention." She paused. "But I'd like the tribunal to consider what the alternative looks like, not in legal theory, in practice." The display she activated was simple. 3 columns. On the left, the 340 violations, date and location. In the center, the crisis occurring at each date and location when humans intervened. On the right, the status of the Council's authorized response at the moment of intervention. The third column was the trial's verdict, made visible. If verdicts could be made visible by data, under debate. Tabled for assessment. Awaiting committee approval. Deployment pending logistical review. Authorization delayed due to procedural objection. 340 times. People were dying. The authorized process was not there. Holden said, We broke your laws 340 times. 340 times, someone was dying and your laws said to wait. We chose not to wait. She let the display stand a moment longer. Convict us if you must. A pause that the chamber's acoustics made very long. We'll do it again. She sat down. The arbiters retired to deliberate. Voraan's fellow arbiters took their positions across the table. Cynic favored conviction. The law was clear, and a verdict based on sentiment rather than evidence would undermine the tribunal's authority in every subsequent case. Dorr favored acquittal on moral grounds. The testimony had established that the law, as applied, had failed in 340 instances, and a law that fails the people it's designed to protect cannot command the same weight as a law that works. Both positions were logical. Both positions were defensible. Voraan was the deciding vote. He processed. His crystals flickered continuously, more complex analysis than he had run on any case in 2 centuries. The processing was not difficult in the sense of being emotionally difficult, because Marathi did not experience difficulty in that biological register. It was difficult in the computational sense, genuinely hard. 2 valid conclusions, each supported by coherent reasoning, each undermined by the other's validity. Law, clear. Precedent concern, valid. Conviction, legally correct. Testimony, irrefutable. Real people were alive who would not be. The law was designed to protect people. The law had failed to protect people 340 times. The people were alive because humans broke the law. The precedent of breaking the law was dangerous. The precedent of the law failing was also dangerous. Both were true. Both could not be resolved by applying one to exclude the other. The discordant tone sounded, then continued. His fellow arbiters waited. He processed for 6 hours. His crystalline structures produced patterns he had not produced before. He pulled every precedent that touched on the case's core tension, the sovereignty framework versus humanitarian obligation, and found that they pointed in opposite directions. The framework cases supported Theskvan. The intent cases supported Holden. Precedent had a coherent legal answer for each half of the question. It did not have an answer for the full question. Then, at hour 6, something shifted in his processing that he could not classify using existing labels. His crystals produced a pattern that incorporated elements of the steady blue, the rapid flicker, and the bright pulse simultaneously, without resolving to any single state. A pattern that was not computation settling on a conclusion, but something that preceded it, or accompanied it, or was perhaps a different category of process than the one he had spent 200 years performing. He sat with it. He thought about the ambassador's daughter who was alive. He thought about the wounded enemy soldier who was alive. He thought about 200,000 Velni who were alive. He thought about 8,000 refugees who were alive. He thought about Holden saying, "We'll do it again," and meaning it and being right that she meant it. He thought about Thespan being correct. He thought about the third column of that display, under debate, tabled, pending, delayed. He thought about what the law was for, not what it said, what it was for, and then he decided, not calculated, decided. He would think about the difference between those 2 words for a very long time afterward. He rendered the verdict for 40 minutes, the longest in tribunal history. He reviewed the law. He reviewed the evidence. He reviewed the testimony. He stated, clearly and without softening, that humanity was guilty of all 340 charges. He stated, clearly and without softening, that Theskvan's precedent argument was valid and required acknowledgement. He stated all the things the law required him to state. Then he said, however, the chamber, which had been very quiet, became quieter. He ruled guilty on all charges. Sentence, formal censure, to be recorded in the tribunal's permanent archive. No penalties, no sanctions. No restrictions on humanity's forum participation. The censure acknowledged the violations. The absence of penalties acknowledged the lives. He added an unprecedented element, a judicial recommendation, not binding. The tribunal issued recommendations, not mandates to the council. But it was in the record. He recommended that the council review its intervention authorization procedures with specific attention to response times during humanitarian emergencies. He cited the display Holden had shown, 340 emergencies, 340 delays. He said the law exists to protect sovereign rights. It should not exist to protect sovereign indifference. When the Council's procedures consistently fail to deliver aid before people die, the law has not been broken by those who intervene. It has been broken by those who do not. He paused. His crystals were producing the new pattern, the one that wasn't pure calculation. He said, Dr. Holden stated that humanity will do it again. This tribunal believes her. The appropriate response is not to punish humanity for intervening. It is to build a system where intervention is unnecessary because the authorized process works. He struck the gavel. In the corridor after the session had adjourned, Voraan watched from a measured distance as Theskvan approached Holden at the defense table. The Catheri's exoskeleton produced the click pattern his translator rendered as genuine respect, the involuntary kind, the kind that comes before conscious decision. He said, "You were guilty. You should have lost." She said, "We were guilty. We were also right. Those aren't always the same thing, but this time they were." She looked tired, Voraan noticed, not strategically tired. Actually tired, the way a person looks when they have carried a very heavy thing and have just been allowed to put it down. Small and silver-haired and tired, with a cane and a case that no major firm would take, and a jury of strangers she had chosen to trust anyway. He returned to his chambers. His crystals were still producing the new pattern. It didn't fade. He processed this. In 200 years on the bench, he had always calculated verdicts. The calculation was sound, the method reliable, the results defensible. He had never questioned it. Why would he? Calculation was precise. Calculation was objective. Calculation was what Marathi did. This was the first verdict he had decided. He processed the difference for a long time. The calculation told him what the law said. The decision told him what the law was for. Two different operations, both using the same evidence, producing two different outputs. And only one of them, he understood with the cold clarity of a species that did not do feelings but did do honest self-assessment, had done justice. He suspected humans would have a word for it. They generally did for things his species didn't. He would, he decided, find out what the word was.